Unfortunately, in almost all cases in federal court, a defendant is going to have to talk about sentencing with defense counsel. Sentencing is the most important part of almost all federal cases. Most people tend to focus upon trials, and we focus upon trials as well. But if we look at statistics from the Department of Justice, over 95% of cases plead guilty. Um, there's always a sentence under those circumstances. Of the sentences that go to trial, the cases go to trial, the Department of Justice tells us that more than 95% of those people are convicted. So acquittals do happen, and we have had a number of acquittals, but you should never start the case assuming that it's going to be an acquittal. So what is sentencing in federal court? Unlike most state courts, there is never or almost never an agreement to a specific sentence in federal court. Rather, the judge will hear the evidence. He'll get a pre-sentence report from the probation department. He'll get memoranda from the prosecutor and from defense counsel, and then the judge will figure out what an appropriate sentence will be. We often talk about the United States sentencing guidelines. Those used to be mandatory, but now they're no longer mandatory. But basically, they set out a grid where, in a theft case, you look at the value of the property that was stolen, you look at the person's role in the offense, you look at whether a computer was used, you look at whether there's, innumerable other factors. Those factors are then used to find a score. That score ranges up into the 40s, but each score is then paired with the criminal history to come up with a sentencing guideline. That guideline is set forth in months. It could be 36 to 60 months. It could be 118 to 136 months. Those are just random numbers. I don't know offhand, but the bottom line is it's supposed to be a mathematical equation that gives a sentencing range for the court to consider. However, all cases are different. The motivations for committing offenses is different. People's personal history is different. Their intellect, their IQ, whether they're under some sort of disability, whether they truly understood what was going on, whether they were pursuing some other greater good. Those are all factors that can be used to argue that sentencing guidelines do not apply. And in the vast majority of our cases, the judges do not apply the sentencing guidelines. In most of our cases, we find that the judges go below the guidelines for any number of reasons. But the important thing is to start at the beginning of the case, figure out who the client is, what's unique about the client, what do they have to offer the world? Is there some sort of educational benefit they have? Have they worked hard and contributed to their community? Have they been active in their church or their synagogue or their mosque? These are all things that make people unique. And if there's something that the judge can connect with, then the sentence is likely to be lower than if defensive counsel doesn't do anything, defendant doesn't do anything. They just look at the pre-sentence report from the probation department and move forward. We always, or nearly always, file a sentencing memorandum. We nearly always collect witness statements. And we believe that putting the time and effort into those cases can really benefit clients. And for many of our clients, it certainly